The Supreme Court on Thursday ruled that a black Mississippi death row inmate can pursue renewed challenges to his conviction, with Chief Justice John Roberts and Justice Brett Kavanaugh joining the court's liberal wing in a 5-4 decision. The ruling highlights differences on the conservative majority court over how aggressively to police claims of racial bias in jury selection and reinforces precedent barring discrimination against black jurors. It reopens a decades-long legal battle for Tara Pitchford and sends his case back to lower courts, where his conviction and death sentence could again be reconsidered. Mr. Pitchford is now entitled to a fair trial in the state court. Joseph Perkovich, who argued the case for Pitchford at the Supreme Court, told the Associated Press a fractured conservative bloc over racial bias. At issue was whether prosecutors improperly removed black prospective jurors during Pitchford's 2006 capital murder trial, in which he was sentenced to death for his role in the robbery and killing of grocery store owner Reuben Britt in northern Mississippi. Prosecutors struck 4 of the 5 eligible black jurors, leaving a panel with just 1 black member, prompting objections from defense attorneys who argued the moves were racially motivated. The case turned on the court's 1986 decision in Batson v. Kentucky, which prohibits excluding jurors on the basis of race and requires courts to scrutinize prosecutors' explanations for such strikes. Pitchford's lawyers contended they were not given a meaningful opportunity to argue that those explanations were pretextual, a conclusion a federal district judge reached in 2023 when overturning his conviction. That ruling was later reversed by the Fifth Circuit Court of Appeals, which sided with the Mississippi Supreme Court in finding that Pitchford's attorneys failed to properly preserve their objections during trial. The Supreme Court's decision Thursday effectively rejects that reasoning, clearing the way for Pitchford's claims to be reconsidered. The court made clear that Batson cannot be sidestepped, said Jessica Ellsworth, partner and co-head of the Hobon Levels Appellate and Supreme Court practice that served as Pitchford's pro bono counsel. If a defendant raises a discrimination claim, courts must assess whether the prosecutor's reasons withstand scrutiny. Legal experts say the narrow ruling signals a continued willingness by the court to intervene in cases involving allegations of racial bias, though by the thinnest of margins. Joshua Dressler, a professor of law emeritus at Ohio State University, told Newsweek via email, "Inevitably, the job of preventing racial discrimination by prosecutors is in the hands of trial judges. They must be vigilant in ruling in Batson cases. Too often trial judges accept the pretextual claims of prosecutors. Here, the Supreme Court, albeit by a slim majority but a majority nonetheless, seems to be sending a message to trial judges to treat the Batson ruling, which seeks to guard against racist efforts by some prosecutors to keep black persons off juries, as a constitutionally important ruling." What Brett Kavanaugh wrote. Kavanaugh wrote, in part, for the majority opinion, the trial court did not afford Pitchford's counsel a sufficient opportunity to rebut the prosecutor's proffered race-neutral reasons, and never determined whether the prosecutor's stated reasons were pretextual. He added, whether due to confusion, oversight, an overly hurried jury selection process, or some other cause, things broke down, and the ordinary trial court procedure for resolving Batson claims at Step 3 never occurred. What Neil Gorsuch wrote. But in dissent, conservative Justice Neil Gorsuch said, in part, the record showed prosecutors offered legitimate, race-neutral reasons for striking the jurors, arguing the majority gave too little weight to those explanations before writing. One prospective juror had returned late to court after lunch break and had a history of mental problems. 2 had brothers who had been convicted of violent offenses. Another had no opinion on the death penalty. Return of Doug Evans and the Shadow of Flowers v. Mississippi. The case closely mirrors Flowers v. Mississippi, a 2019 ruling in which the justices threw out another conviction involving the same prosecutor, Doug Evans, for what Justice Kavanaugh described as a relentless, determined effort to rid the jury of black individuals. Evans also prosecuted Pitchford, and the same trial judge, Joseph Flipper, presided over proceedings in both cases.